Hi, my name is Nick Zappi. I'm the Director of Business Development at Business Credentialing Services, and we're a risk management company that helps our clients protect themselves from third-party exposure. The question I'm here to answer today is, how does BCS help protect your property? And the emphasis in New York City has to be on Labor Law 240. So let's look a little bit into the history. In 1885, New York City was getting built up, and I mean vertically up in the air. And as you can see, most of the scaffolding used was wood-based, and wood was prone to things like collapse. So they enacted what first became known as the scaffolding laws, which finally gave an injured employee the legal recourse against their employer for an unsafe work environment. And over time, these laws changed into what became known as Labor Law 240. And although the laws were changing, you could see the emphasis on workplace safety did not always keep the same pace. And then something wonderful happened in the earlier part of this decade. Lawyers got involved, and lawyers said, why is it just scaffolding? What about my injured painter? What about my plumber? What about my electrician? And basically they created a term called elevation differential that was so broad that basically stated absolute liability for injuries resulting from gravity. And essentially this gave the power to an injured employee now to get vicarious liability from either the owner of the property, the general contractor, or both. So when workers' comp was unsatisfactory, they could file a lawsuit against either the property or general contractor for these unsafe work environments under Labor Law 240. So essentially the first remedy for the property or the general contractor would be to pass this off to their commercial general liability policy. But the insurance company said, well, there's no defense for an unsafe work environment, and we can't anticipate these types of claims. Are we going to provide coverage? No. So what happens when you take no pre-loss intervention, check the underlying policy to see that there's no labor law exclusions, and you mix in some good lawyers? You start to get claims that look like this, and you start to get lawsuits and verdicts and settlements like 2012. You can see here a labor law worker suffers permanent loss of leg use after 30-foot fall, $15 million. You can see the types of people being sued, 346 West 17th Street. Additionally, 2013, defective saw and partial collapse of an excavation, $20 million. Demolition, large falling pipe struck plaintiff in the head, causing a fall from a 12-foot scaffold, $11 million. Masonry supplier fell off a roof, $6 million. And then my favorite, in 2014, $62 million. Laborer fell off roof, claimed disabling injuries of brain and spine. So, by going to market with loss runs that show these types of claims, you could have your premiums go up, you could have your insurance canceled on the property. Regardless of if you can absorb these losses, it may make the overall costs go up over time. So what can be done? Most people say collect a certificate of insurance. Well, what does the COI actually guarantee? If we look here on a standard Accorum Fortum at the top, it states this certificate does not affirmatively or negatively amend, extend, or alter the coverage afforded by the policies below. So when collecting a certificate of insurance, you may see certain coverages, but if those coverages are incorrect, it does not change the underlying policy. So what does the COI actually guarantee? Nothing. In addition, what else would you have to do? Well, you have to collect a declarations page and forms list. A dec page will declare exactly what the policy limits are, and in addition, and more importantly, the class codes of which that vendor is insured for. So if you have an interior contractor who says, I'm going to patch something on the roof, and they're not insured for a roofing class code, they have no coverage in the event of a loss. In addition, you need a forms list. The forms list is going to tell you what's included in the policy, but more importantly, what's excluded. And the things that we want to look for in terms of exclusions are everything applicable to Labor Law 240. Now, when you get some of those forms lists, you may see a document that looks like this, and in there it may have a section that says something like this. This exclusion does not apply to liability assumed by the insured under an insured contract. So what else would you need to make sure that there's an insured contract prior to any work or any loss? Well, you would need a hold harmless agreement, and First Service passes it out to all vendors, basically doing two things: one, indemnifying, and two, laying out what insurance is needed. This way, an insurance company cannot deny coverage because there wasn't an insurance contract in place prior to loss or work starting. So the real question becomes, so what are the job responsibilities when working in New York City? And this isn't First Service Residential or BCS's requirements. This is for any successful risk-averse company. The first is collecting a certificate of insurance with the correct information, and that's a value-added service because you're constantly looking for renewals and making sure there's no lapse in coverage. In addition, you've got to review policy pages and make sure there's no exclusions on the forms list and make sure the dec page class codes match up with the type of work being provided. In addition, a signed hold harmless agreement, making sure that there's an insured contract prior to any losses or work starting. Probably want to collect some DOB and DCA licenses, and then a W-9 for potentially any billing purposes. So the real question is, how do you manage this for every vendor that's going to walk through your door? There's a tremendous amount of administrative burden, and it's a very difficult process to have the wherewithal to make sure that you're collecting all these things properly each time. That's where BCS steps in, and this is the BCS difference. BCS has a dedicated insurance team. All we do is work on First Service New York vendors and properties, and the properties and exposures that they're looking at. In addition, we're just concentrating on the type of labor law claims, making sure that we're looking at deck pages and forms list so that nothing could come across in the form of a lawsuit, and if it does, that we could pass it back on to the appropriate parties. And all of our team is dedicated strictly to First Service New York. So in the event that someone has any information that's needed, they can always reach out to a dedicated team member. Next, we provide everybody with a Certus database. Our database aggregates all of the vendors that work for First Service New York and supplies you with alternatives in the event that you know that someone may expose your building to unnecessary liability. If you love an electrician but know now that you could have a $10 million claim come across, you may want to use someone that has actual protection in case your electrician doesn't have an umbrella policy or has a labor law exclusion. This database is accessible anywhere from a cell phone, from a laptop, and basically you can pull and run reports to make sure that all compliance is being met in your building. And then lastly is our CCP method, which is collect, correct, and protect. So this methodology, we basically have quick turnaround time, but more importantly, we want to monitor for 12 months of the year. So in the event that insurance is changing or renewals coming up, we want to make sure that those vendors are never going to have a lapse in any sort of coverage. In addition, we are a company that focuses on making sure that any of these losses, because loss cannot be prevented, at least we can maybe mitigate them and put them to the responsible parties. So I thank you for your time, and if you have any questions, please feel free to reach out to us. Take care.